A judge says no recusal. A politician says bias. And the courtroom becomes a stage for a bigger question. Well, who defines judicial fairness in politically sensitive cases? Notably, on April 20, 2026, the Delhi High Court, in a significant ruling, saw Justice Swarana Kanta Sharma refuse to recuse herself from hearing a petition in the Delhi Excise Policy case involving Arvind Kejriwal and others, including Manish Sisodia. The plea came after Kejriwal, appearing in person, sought her withdrawal from the matter, citing a reasonable apprehension of bias. Well, the case arises from the controversial Delhi Excise Policy, that is 2021-2022, which has been under investigation by the Central Bureau of Investigation, that is CBI, and the Enforcement Directorate, that is ED. Well, the agencies have examined allegations such as policy manipulation, cartelisation in the liquor trade, and alleged kickbacks connected to the changes in the excise regime. Although our trial court discharged Kejriwal and other accused in February 2026, strongly criticizing the investigating agencies, and the CBI challenged that discharge order before the High Court, bringing the matter into appellate scrutiny. Well, what has been the recusal plea? The perception over proof. Kejriwal's argument did not claim proven bias. Instead, it focused on whether circumstances created a reasonable perception of partiality. He pointed to alleged participation of the judge in events that is linked to the lawyer's body perceived to have ideological leanings, concerns about the professional roles of her family members within the legal ecosystem. Earlier, judicial observations in the case, which he said appeared unfavorable or premature. And his core submission was that justice must not only be fair, but must also appear to be fair to maintain public confidence in the judiciary. Well, what has been the court's response? That is, perception cannot override duty. Justice Sharma rejected the recusal request, holding that mere perception or apprehension without concrete evidence is not sufficient to disqualify a judge. And the court stressed that subjective apprehension alone cannot form the basis for recusal. Accepting such arguments could encourage strategic attempts to disqualify judges. It could also lead to floodgates of forum shopping in politically sensitive matters. Judges cannot be disqualified merely due to relatives' professional involvement in the legal field, and judicial impartiality is presumed unless proven otherwise. Well, the court further observed that recusal cannot be allowed to become a tactical tool in order to avoid unfavorable benches or delay proceedings in complex cases. And doing so, it warned, would weaken judicial independence and disrupt the functioning of the justice system. Well, let us understand now the broader context of the case. The Delhi Excise Policy case has been one of the most politically charged legal battles in recent years. It has involved multiple investigations, arrest, and sharp political controversy. And the trial court's decision to discharge the accused in February 2026 added another layer of debate, especially after the CBI challenged that order in the High Court. But why this ruling matters? And this decision goes beyond a single recusal plea. It reinforces a core legal principle, that is, judicial independence cannot rest on perception alone. And at the same time, it highlights a continuing tension in high-profile cases, that how courts balance public confidence in impartiality with the need in order to prevent misuse of recusal request for strategic advantage. And with the recusal plea dismissed, the focus now shifts back to the central issue before the court, that whether the trial court's discharge order can survive legal scrutiny on its merits. That's all for now. Stay tuned to the Savera for more updates. Do like, comment, and subscribe to the channel.